Let's get going. Thank you so much, everybody, for joining. It's so great to have you at our industry update this month. I'm Jill Cox with Heritage Title. And as I always like to do, I want to start by letting you know about our upcoming updates. So save the dates. Next month, May 5th, we're going to have Marcia Waters joining us from the Division of Real Estate. As you've probably seen, her updates are always super fun and entertaining, so definitely don't miss that with Marcia. And then on June 2nd, we're going to have a legislative review with attorney Liz Peets from the Colorado Association of Realtors. She's going to be telling us about what happened at the legislative session this year and what upcoming legal changes we're going to see that are going to impact our industry here this next year. So, and we'll certainly have continued updates after that. We're just finalizing our future guests. So just continue to save the date, 2 o'clock, first Thursday of every month.
With the exception of July.
Except July, we are going to take the week off in July. So happy
4th of July. So everybody can go have fun.
Exactly.
I know they were going to give up their 4th of July plans to spend with us, but.
Right. Yeah. Don't cancel those plans. Okay. So back by super popular demand, Pete, is this your third time on our industry updates?
I lost count. I don't know. They all become a blur, like, wait a minute, is this being recorded? What? Yeah.
So we're super thrilled to have you back on. Everybody asks when Pete's going to be coming back on with another update. Obviously the last couple of years with COVID and everything else, there were just constant changes with regards to landlords and owning rental property. So we're delighted to have you back on today to give us an update on where things stand now and what things are going to look like going forward. So for those who haven't met Pete before, Pete Muccio is a senior associate attorney with Cheddar Sulzer. He practices in the area of landlord representation and has done so since 2003. His practice encompasses a wide range of issues, but with a heavy emphasis on litigation arising out of landlord-tenant disputes. He presents CE courses for real estate brokers and attorneys, and is a regular contributor to Cheddar Sulzer's online educational workshops known as Webinar Wednesdays. And personally, he's a marathon runner and also enjoys poker, hiking, skiing, and struggling at golf, which I enjoy struggling at golf myself. So I think a lot of us do. But with that, I just want to give a big welcome to Pete. As always, Mr. Cox, Damien is joining as well. So we're looking forward to a great discussion today. Please put your questions in the Q&A and we'll do our best to get to as many of those as possible. And from that, I will stop my share. And Pete, do you want to go ahead and kick things off?
Yeah, absolutely. Absolutely. Here, let's see. I probably need to get my share going here too.
And I will mention, I am home with a sick kid. So if I have to step off screen for a second, I'm managing a 3.5-year-old who has Tylenol on board now. So he's kind of fine, but is still sick. So we'll see how this goes.
Kind of fine.
Well, Jill, thank you very much for that warm introduction. And it's just always a lot of fun to sit down and talk with you guys, and just really enjoy the opportunity to be here. So I know it's when I'm talking about something, it's not always good news or great news, but I've got some mixed news to talk about. So let's see, did that pop up okay?
It did. Imagine that, a lawyer with bad news, Pete, really.
I know, right? Never happens. Okay, so let's talk about kind of the new landlord-tenant laws and really from a state perspective, what's going on. We're going to go backwards. We're going to go backwards in time. So we'll start with 2022 session, which is still ongoing right now, right? So there's laws that have been proposed. They're not laws yet, but they might be laws. Some have been passed, and we're just going to run through some of those. Then we're going to go back in time, hop in the DeLorean for a little bit, and go back to 2021, talk about the laws that really had a big change on landlord-tenant relationships, and really how some of those things have played out. We can kind of talk about how some of those things look and answer some questions, and yeah, just kind of go from there. Sound like a plan?
I think that sounds great. I'm sure everybody's wondering what impact you've seen on some of those laws, but why don't you start with the explanation? So
Yeah. So the 2022 session, we've got, first of all, we've got HB 22-1287, and that's really a focused on the mobile home industry, right? And it's a huge overhaul. And if you have any awareness of what's going on with mobile homes over the past few years, it keeps changing. It's a moving target. It's been a popular focus for the legislators, and they're really looking at this as an affordable housing area, and really trying to change some rights around, taking rights away from property owners, meaning who owns the mobile home parks, and giving more rights and more power to government and to tenants. Typically, tenants will own their own mobile homes in these mobile home parks, and it's a big change. One of the things, and one of the reasons why I want to bring this up, because I don't think a lot of people on this call are focused on the mobile home industry. So you're thinking, Pete, why are we talking about this? The thing to be concerned about is there's also talk in here about dealing with rent control, right? And limitations on parks owners' ability to increase rent. And that there are aspects of what has happened in mobile home world that has impacted the conventional world too. So it's something to be aware of. We'll see if it's going to pass or not. It seems to be moving through the House, and it moved through a committee pretty easily. And I have a feeling that we're still going to be talking about this one, and it might get passed. We'll see. The next law really probably has a larger impact on multifamily, but I bring it up too because it could have an impact on some of the people on this call, and that is some changes in towing laws. And this is HB 22-1314. And really what this would do is would have a big impact on how towing operators can operate and how much they can charge. And why is this a big deal? Why is this important? Because if towing operators can't operate and you got a parking problem, what are you going to do? So there is a need for towing companies. They provide a service, and it's a service that, you might not think of it as a service if you've been on the wrong end and had a vehicle towed. But if you've had a situation where, you've had somebody parked in a handicap parking spot that didn't have a handicap placard, it really can be pretty important. So there's a potential big shakeup there. Not sure what's going to happen with that. There've already been some news articles that have talked about it, and we'll see. Another bill is the HB 22-1082. This is an authorization for a housing unit within the Attorney General's office. I expect this to pass. And I've done some work on this bill in coordination with the Colorado Landlord Legislative Coalition. Basically had some dialogue with some of the sponsors, with the AG's office about making some modifications and some amendments. There was actually some good dialogue there about trying to make sure from the housing perspective that the AG wasn't going to be empowered to just become the housing police, right? And get involved in every single housing dispute. What this is going to do is it will give the Attorney General's office the ability and authority to investigate and pursue things when there's reasonable cause, basically when things have been happening on a larger basis. So it shouldn't be a situation where they're getting involved in one-off situations, but more of focused on the bad actors that are involved in violations of laws related to mobile homes, security deposits, rent increases, discriminatory practices, a whole bunch of things. And really, this is just the beginning of the oversight that the Attorney General's office is going to have in housing. It's just the start. We're going to see that probably evolve over the years and probably grow. And it's interesting because one of the things, we're in a highly regulated industry, right? I mean, most of the people on here are probably licensed brokers, I'm going to guess, right? So you're already dealing with oversight. You're already actually dealing with some connection with the Attorney General's office because they work with DORA and dealing with enforcement actions that don't get resolved and have to go through the administrative court process. But this is a whole other level of involvement in housing, and it would affect not only those with a license, but those without a license, right? That could fall into a violation and could be targeted as part of an investigation by the Attorney General's office and potential prosecution. So that I do expect to pass. It passed the House. It's been amended in a Senate committee, and I do expect that we will see that signed into law. Another actually new law, this one has been signed into law, and it will be effective, I believe, after the session ends, probably 90 days after. And this is basically, it increases access to sealed eviction records. And really, this doesn't have a huge impact on anybody as far as the operations of what they do in dealing with an eviction or anything like that. But what you really need to know is that eviction actions right now are sealed when they're filed, and they're not unsealed until there's a judgment for possession that would enter. And they can then be resealed if the parties agree to seal them back up or they agree to vacate the judgment. But what some of the tenant advocates have found to be a challenge is when a case is sealed, it's really sealed. I mean, it is hard to get information about the case unless you're a party to the case. And so it created some challenges for the different organizations, different attorneys that were trying to get involved with a tenant and getting information about a case before, before court dates or, just being engaged and learning anything about what was going on unless they entered an appearance in the case. But it was even difficult for them to enter an appearance unless they had a case number. So there were a lot of challenges. So this is kind of a cleanup of the existing law that deals with the sealed records, but it doesn't have a huge impact on the practical operations of property management. But it did pass.
So real quick before you go on, Pete, there was a question on the mobile home proposals asked if it includes modular housing, and I'm assuming. Well, why don't you take that if you want, or I can.
So I think it's really geared towards mobile home parks, right? And so that's where you're talking about, if you're talking about a modular housing situation, if it's not a park, I'm not sure that that's going to trigger an application. So it's really geared towards mobile home parks. But off the top of my head, that's my quick answer. It's also 50 pages worth of legislation. So if you wanted to double check that, you feel free to look up on the legislative website and you can pull up the bill and do a quick search if the person who asked that question really wanted to dive into that a little bit deeper.
Yeah, and that's my understanding too, is that it's applying to parks, and they've had so much overhaul in that in the last 5 years of adding arbitration and dispute resolution and ability for people that own, if the park decides to sell, that the owners can get together and try and buy the park. I mean, it's been just a big, colossal, fun place to play. I'm glad I don't have to do it.
Yeah. So I did testify in committee against that bill as well. And it was interesting. The sponsors of this bill were involved in some of the legislation in previous years, and they talked about that almost as a positive thing that they were engaged with it. But I think the flip side of that is like, hey, that's not really great. You've already kind of dealt with this. You don't really need to kind of make this modification again. Is it really helpful? But we'll see.
Yeah, politics is politics, right?
It is. So, well, let's talk about some of the new laws that did go into effect. All right, we'll go into the time machine. We'll dip back a little bit, and there were a couple of laws that really had a big impact on the property management world. And this was 1121 and 173, and we've already seen a big impact on the current operations, and I think that's just only going to continue as this sort of plays out. So the 1121 immediately went into effect back in June of 2021, And then 173 didn't become effective until October of 2021. And so really what these required was they required modifications to your lease agreements, right? So there was a need for changes to your lease agreement moving forward, and there was a need to deal with what we like to call cutover issues, because most people's leases, I'm going to say, are probably 12 months. Some are maybe 6 months, and pretty sure, at least I haven't seen a lease agreement that was put together in 2020 that contemplated the law changes that were going to go into effect in 2021. So you had this situation where you had these kind of cutover issues of, okay, what do you deal with? How do you deal with a lease that was, valid under 2020 law, but now under 2021 law, it's not? And how does that sort of impact? So we'll talk about those issues a little bit here too. So the big one with 1121 was there was a limit in rent raise increases, right? So basically a landlord can't increase the rent more than one time in any 12-month period of consecutive occupancy by the tenant. Okay, well, that sounds pretty straightforward, right? You can only have one rent increase. How harmful could that be? Well, it has a lot of impact. There's been a big impact of that. Because, first of all, if you just break it down, what's the 12 months of occupancy? Where are you going as far as your calculation on when you are going to measure those 12 months? Are you measuring from prior to when the law went into effect? Are you measuring from when the law went into effect? What's your 12-month time period, right? Also, there's a big problem. It's kind of a cutover issue. What about a rent increase? So it was very common to have language in your lease agreement that talked about something as a fee would be additional rent. Well, if it's additional rent and it gets charged, is that suddenly an increase in your rent? Did you just raise the rent inadvertently? The oops, I raised the rent situation? It's certainly a possibility, right? And we've raised this as a potential issue. We have not seen it play out that somebody has gotten hit with this argument that the rent was increased because they added Fluffy the pet and suddenly their rent went up $100 a month, right? And saying, oh, it's time for a renewal. Oh, you can't raise me $500 because I added Fluffy and it already went up $100, right? So you could see there's still the potential for some tension around this issue. And we'll see how that kind of plays out. It hasn't really played out too much yet. We haven't seen that happen, but it's a possibility with the way that the law is worded.
So just real quick, if you go back, Pete, to that, so they add a pet and you add pet rent or whatever, and it increases the rent. I could see where that would be an issue. And obviously only 3 months in, 6 months in, we may not see the repercussions yet. How are you advising landlords on dealing with that? Or have you guys come up with something? Or are you kind of waiting to see how the chips fall? I mean, what's your thoughts?
Well, one is you can look at it and you can say, look, well, I'm not going to add that fee because I'm not going to risk it. Could be super conservative. And, like everything, there's a range of ways that you can take to approach things, right? Another way would be to say that, look, this was a lease and this was a charge that was authorized under the prior law. This is not intended to increase the rent. The law talks about an increase in rent. This is an additional rent. It's really kind of a fee. It's not really what this law was designed to target. You could make that argument that this is really talking about an increase in the base amount of rent to justify this newer rental amount. The law doesn't say anything specifically about any additional fees or those fees being classified as rent, but we just don't know how that'll play out. So it's really, you kind of have those two extremes, right? Do you just avoid it in the hopes that you can deal with a rent increase in the future? Or do you say, look, this was a fee for Fluffy. you added Fluffy. Fluffy wasn't here before, right? So it's a new tenancy in a sense because it's you and Fluffy here, as opposed to just you. So it's a justified change. I think the fairness kind of favors the landlord, but I'm a little biased, right? So I'm not sure. I could see it playing out depending on your judge too. I think the other thing that's interesting is that it's probably something that would play out in a situation where the parties were pretty adversarial against each other, and where the relationship had deteriorated, where there was some sort of a default. And I think that's where this would probably get tested. So I think for the most part, if the tenant's in a property and they're paying rent or they've paid an increase in rent, they want to be at that property, right? So where are they going to be kind of bringing this issue up and trying to make this argument? So it's probably likely to be in front of a court when there are other issues between the parties going on too. So we'll see if it happens.
Before you go on to the next, are you still on additional rent? I'm sorry. We have a couple questions on the new stuff too that I thought I would ask you, but we can finish
Sure.
up this if you want.
Yeah, go ahead. I mean, we've got, let's see, what are we? We're on 8. Actually, yeah, this would be a good time to talk about those things.
Okay, so the question is on the eviction record seal. It says, if an eviction record seal, does that cause it to not show on a typical eviction check report that is run via Zillow or other rental applications? With this new law, will it make getting access to eviction records easier when screening tenants?
No, it's not designed to help landlords at all. It's designed to help people that are advocating for tenants that are going to enter into a case. And if a record is sealed, it's probably not going to appear on a check. You know, it just sort of depends on how the screening company harvests their information and how frequently they harvest their information. It's quite possible that an eviction action could remain sealed completely from the time that it was filed, depending on what the agreement of the parties were, which, if that was the case, the only way that you would find out about it is if the tenant was honest that there was, when they were filling out their application, that there was an action that was filed against them.
Okay, the next one comes from Jay, so it's long. House Bill 22-1082, the creation of the Fair Housing Enforcement Unit under the Attorney General. Are they only going to be targeting licensed brokers, property managers, or are they also going to be able to go after individual landlords that violate fair housing? He says he's noticed an increase in tester calls, tester emails, and even tester text messages received over the last 12 months from agents. He says entrapment agents, but obviously testers. If the Attorney General's new unit is going to go after the individual landlords, the existence of the new unit might, well, he has opinion that it might be great. What do you know what that's going to ultimately try and do? Is it in general, or is it aimed at something else?
So it is in general. So it could go beyond just the licensed brokers. It is going to be, it's set up to be complaint based though. So at least at this time, it's not set up to be a primary, like the AG is supposed to be initiating something based on, a referred complaint. And then, their action for an investigation should be based on having that cause that multiple parties are being impacted type of thing. So the situations as far as the testers, I think that is going to continue. And that's probably, there's a lot of groups and organizations that do that in order to look for cases and look for situations where people are violating the law, right? And so I think that behavior is going to continue. But I believe the setup with the AG is going to be more of a reactive based on a complaint, and then they'll have specific authority to be able to subpoena records and to be able to do a pretty thorough investigation based on the complaint.
Yeah, thank you. I think that's a good answer to that. I think I saw a question on pets, since we can go back to your outline now. It says, regarding pets, if you raise rent on January 1st and they purchased a pet in March, is that 2 increases? And I think what you're saying is that's open to discussion depending on what the, what the judge says that you're dealing with.
It is. Yeah, it is open to discussion. I mean, I think it's very fair to say that, hey, look, that's not a rent increase. This is a change in the tenancy, change in the makeup of the tenancy, right? Because Fluffy's now part of the team. But it's not, there's no guarantee on the interpretation of that. And ideally, if your lease is calling it a fee, a pet fee, and not additional rent, then you have a really good argument that that's not increasing the rent, right? So that would have been something if you had revised your lease or had that revised that could help address that issue.
Great. I'm caught up now.
All right.
Well, there was one more question that came in real quick.
Oh, sorry.
Can an HOA fee increase be used for a rent increase?
HOA increase be used for fee increase? Well, I guess it kind of depends on your lease. Favorite legal answer, right? It depends. There's a possibility that you could say, hey, look, we just pass these fees on, right? If utilities go up, which utilities are going up, is that really a rent increase? If you're responsible for those fees in the lease specifically, I think it's going to be difficult to say that that is an increase. I think the problem here that I'm trying to highlight as far as the risk of the inadvertent rent raise would be, say beyond a pet fee, say there's some fee that was assessed for some sort of a violation, and that was called additional rent, whatever that fee might be. If it was called additional rent, that could create that concern for raising the rent. What that would do is it might not prohibit you from assessing that fee, but it could create a prohibition when you try to raise the rent on that same tenant in the future. That's where the risk comes in with this, right? So,
yeah. All right, let's move on because we're half hour in and we got through 4 slides.
So cutover issues. So basically, you got to determine how you want to deal with it. Like if you're talking about late fees, which I'm going to roll right into here in a second, and your lease was designed in 2020, how are you going to deal with late fees? Do you say, look, there's just no late fees? Usually if I'm talking to a live audience, that gets some chuckles. But we've dealt with a situation where you couldn't have late fees for a while, right? And the impacts that had. Or are you going to say, hey, look, I know my lease charges a late fee that's both too early in time and too high. I'll just reduce it down to what the current statute says. That's certainly a possibility. And I think that's a very justified approach to dealing with that, because you're saying, hey, look, I'm trying to comply with the new law based on this agreement that was entered into that was okay under the previous law. So it's just a consideration that you have to keep in mind. So what are the late fee limits? Well, late fees can't be charged unless the rent payment is late by at least 7 calendar days. Yeah, that's right. So there's no more, a lot of people had a grace period of 3 days, 4 days, 5 days. Well, the rent now, the legislature has basically said, look, we got a built-in grace period, and that's going to be 7 calendar days for the rent being late. Then there's a limit on the amount. You can't charge more than $50 or 5% of the past due rent payment. And you can't charge a late fee unless it was agreed in the lease. I'm not sure why they threw that in there. That was already the law, but they decided to throw that in there again. So we got to talk about it, right? But I didn't draft this thing. Other limitations, you can't just evict somebody over late fees. Now, the reality was this wasn't going on, I'm not sure why they put this in there again, but, landlords trying to do an eviction just because somebody didn't pay a late fee, that really wasn't happening. You can't terminate a lease just for the non-payment of late fees. You can only have a daily late fee if they don't exceed the total limit. And that total limit, again, was the $50 or the 5% of the past due amount of rent. You also cannot recover late fees from a base rent payment. So a lot of times leases would say, hey, look, you make a payment, we're going to apply it to everything else and then base rent. That's now problematic. So that's one of those areas where the lease language probably needs to be changed. So what is a late fee? right? Well, a late fee is very specifically defined. It's a monetary sum that the landlord charges a tenant or homeowner as a result of the failure to timely pay rent that is determined pursuant to a rental agreement between the landlord and the tenant or the homeowner. There you go. So,
and out of curiosity on that late fee thing, Pete, are you starting to see any consequences of these late fees roll in? Or are tenants starting to use that as leverage of, oh, well, I just won't pay the late fee until the lease is over? I mean, obviously there's some problems with this language, but I'm curious as to what you're seeing in practicality now.
yeah, well, I think the practical issue is that we are seeing it raised as arguments in answers in cases if there's an error in the charge, because there are consequences to somebody assessing this late fee improperly, right? So the provision could be deemed void and enforceable. You could be charged a $50 fine for each violation. So if you have a demand that's charging a late fee early, there's an argument that that by itself could be a $50 violation just for violating this part of the law. Now, does that create an absolute defense to non-payment in an eviction situation? We haven't seen that play out where somebody's just completely won the day based on an error in the timing, but it's an issue that they can raise that creates problems for the court and potentially problems for the landlord. So not only that, there's an additional penalty that if landlords are warned about, given 7 days, what does that sound like? Sounds like a security deposit dispute, right? They could be liable for damages of at least $150, not to exceed $1,000 plus attorney's fees and costs. So again, we're not seeing a lot of this play out because I think a lot of people are trying to get this right on the front end, right? That they're trying to make sure that at least on the cases that we're dealing with, there's you want to try to get the fees correct on the front end. So that tries to minimize the potential blowback that you might have in giving up that leverage that you might might be giving away. So there's still more to SB 173 besides late fees, though. There's other prohibited provisions, and these also have a huge impact on the operational side for landlords. Unreasonable liquidated damages that assigns costs to a party from an eviction notice or an eviction action. We've taken this to really be an impact on the ability for landlords to they've got to be very careful when they're talking about lease break fees. So whether there's an eviction or not, and a lot of times there might be lease break fees that result after somebody has been evicted, but even if there is no eviction and somebody just skips, I think this restriction really comes into play. And what's unreasonable and what's liquidated damages? Well, remember, liquidated damages are what might be owed or what might be the damages that the parties estimate at the time that the contract is entered into, right? So they try to make this determination of what those fees might be. If your lease ends up with a result of a 4-month liquidated lease break fee, that's not going to work, right? That's not going to work in this type of an environment where you can get the property re-rented fairly quickly in most areas, right? So probably 1 month, 2-month fee might be justified. Anything beyond that, I think would be very challenging in this particular market. There's also fees have to be, if you're going to have attorney's fees, it's got to be a prevailing party fee, right? It's got to be shifted. It can't be a heads I win, tails you lose situation, right? It's got to be it's got to go both ways. So big change as far as dealing with evictions. The most common eviction is related to non-payment of rent. So under the current law, under the old law, if somebody was served a 10-day demand, they had 10 days to pay. If they didn't pay within the 10 days, you didn't have to accept the money. You could say, hey, look, let's move forward and proceed with the eviction action. Well, that's changed. So the new law, 10 days is no longer 10 days, right? So you can give somebody a 10-day demand. If they don't pay within that time period, then you have the ability to move forward with an eviction action based on non-payment. However, the tenant still has the absolute right to cure, and they can cure what's owed up until the time that the judge enters a judgment for possession. So that means you can file an eviction case against somebody, and the tenant can then cure that prior to the judge entering an order on the judgment for possession. So it's a big change operationally from the way things have been in Colorado for the past, since I've been practicing, 2000, going back to 2003, and even before that, as far as dealing with when a demand would expire and what rights somebody would have to cure that. The reality is, a lot of times people would cure it through an eviction process, and the parties would come up with a settlement. And well, now the tenant has additional rights of when they can cure. So that's a big change.
One of the questions I've had come up in classes I've taught that had something about that, Pete, was what about the attorney fees that the landlord has expended up to that point when the tenant comes squealing in on two tires before the judge drops the gavel? Are those still owed by the tenant, or how does that work?
So I think there's a good argument that those can be owed if you have supporting language in your lease agreement that talks about, look, if we have to go to court and incur these costs and you end up paying it, you're agreeing essentially that the case was justified in filing that case, right? And we've actually modified our rent demand to include kind of a timeline of when, when somebody cures, how much would be owed. So it's very different. It used to be a rent demand would say, hey, you owe X and you have to pay X. Well, now the rent demand's broken down to the point of, here's what your base rent is. Here's what is owed right now. Here's what's owed if your late fee kicks in. Here's what's owed if I have to go to court and file a case with an attorney. It's all included in there. And part of the reason for doing that is because a tenant can cure not only by paying you, the landlord, they can cure by paying the court all the money that's owed. And so the court doesn't have all of your records, right? So they're going to be going off of the demand. And so it's important now that those demands have that information. There's a little bit of math involved. It's not too complicated, but it's a little bit different, right? That's very different. It's a little new. Yeah. And it is a big change for landlords who've been doing things for a while. It's just a big shift.
And this is my favorite one.
You like this one?
Oh my God. What a disaster.
Oh yeah. So basically there was a part of the warranty of habitability law that really limited the ability for a tenant to raise a claim of warranty of habitability in a rent case, right? In an eviction rent case. If they were going to raise that claim and raise that defense, they had to pay the rent into the registry of the court as far as a rent bond. Well, the new law, frankly, my perspective is I think some of the tenant advocates didn't understand that law, didn't understand that concept. And when they argued about this law and tried to push this change through, they tried to make it seem like it was unfair that people couldn't raise these issues of warranty of habitability because they couldn't post the bond. But there was the connection that was missing in that was that they could raise those issues if they had the rent, if they had the legitimate rent, if it was legitimate that they spent the money on something else, that they could post that, or if they were withholding it, then they could post that. So there's still the possibility of a rent bond, but in order to meet the financial requirements, you have to have a very well-off tenant to be able to pass that threshold. So it removed a tool that allowed the courts to deal with kind of the bogus claims. And so we see the warranty of habitability raised a fair amount, and we still have to deal with that. And we don't have that additional protection for landlords anymore.
Are you seeing this being raised more as the bogus claim? Because, you don't have this safety guard of them having to pay the money in anymore. I mean, is it having an impact on slowing down evictions because of this change?
I don't think it's had an impact on slowing down evictions. I think what it's had an impact is it requires additional preparation for dealing with those arguments at the initial stages of the eviction case, because the eviction case is dealing with possession, meaning who's living in the property, and then money issues can be dealt with at a separate time. They're not typically dealt with on the front end, right? So most eviction cases are really just about possession. And what this does is it has the possibility of creating this additional complication of dealing with it more on the front end on the possession piece, or just kind of dragging the case out so that possession might get resolved, but then we're still dealing with these warranty of habitability claims later on, which was kind of always there before. It's just more work, I guess, on the front end.
Okay. And you don't see it slowing things down, because I always figured that if they made it something that was colorable, that the judge would want to have a hearing on it, which would slow down the whole process.
I think it's more of that it's getting addressed in the possession hearing context. So
Okay.
where they wouldn't have that consideration before if the bond wasn't paid, and they could narrow down the hearing. But it's more of something that gets discussed at that point in time if it's related. So it basically creates more work for the court, I think is the way I'd describe it.
And the landlord's lawyer.
And the landlord's lawyer, which, well, it keeps the lights on, right? So yeah, it's a different eviction process, right? There's now a request for documents that are going to be used in the possession action. So there's always been an exchange of documents in eviction actions in any court case, right? Well, this is probably the fastest way to get documents. I mean, evictions are set up to be a very fast judicial process. You know, we talk about things slowing down, and they have slowed down significantly, but it's still very fast compared to almost any other process on the civil side that you can have in the court. But there's now a way that the documents can be requested by a party. They can say, hey, I want to see all the documents that are relevant to my case, which would typically have been shared anyway. But what we're seeing is that gets generated, those requests, in almost every case that there's an answer that's filed. So again, that means more work on the front end for both the landlord and the landlord's attorney. Here's a big one: abandonment. Did my tenant move out? I think they moved out. Are they there yet? Pete, can you tell me? Well, I'm not there at the property. I can't make that call. I can talk to you about things that might be, you might want to look at to see, is there any personal property left? Is there, are there keys left? Was there any communication left that they were indicating that they were leaving? Are the utilities on? What's going on with the property? Well, let's say somebody makes the wrong move and they lock the tenant out. And I have had this situation take place where a tenant gets locked out. They want to turn around. They say, hey, landlord, you need to pay me $5,000. I know I was locked out of the property for, 12 hours, but I want my $5,000. Like, really? I mean, it's so this area has always been a little bit of a multiple landmines for landlords, right? Now those landmines are clear that you can have statutory penalties, and you could have an award of attorney's fees and costs against you in a lockout situation or in a wrongful eviction. So making the determination of whether or not the tenant has abandoned the property, it's a big deal.
Yeah, err on the side of finishing the eviction as opposed to hoping that it's abandoned.
Yeah, exactly. Yeah, be careful on that one. Be careful on that one. So, yeah. So there we go. That's the.
So I got there's a couple of, there's one question here, and then we'll let people type some questions if they have some more. I saw some, but we have one question that somebody wanted to ask about the source of income.
Okay.
Okay. Yeah. And it's with the new law regarding discrimination based on source of income. We know landlords with 5 or less units are exempt, i.e. they can refuse, Section 8. This is what they're getting at. And the question is, does it apply to each individual owner, or does it apply to the property manager and all? What do they count as 5? Is it just the owner individually, or do they count how many the manager has?
If you're managing property professionally as a broker, you have to accept a voucher. I don't care how many properties your owner has that you're working for. It's just that simple.
Yeah, that's a big deal too, because CCRD is, Jay talked about testers out there. The testers I've seen have been the CCRD looking at this source of income as far as in the property management sense and figuring out if people are accepting the Section 8 vouchers.
Yeah, and CCRD, the Colorado Civil Rights Division, they can, if there's a complaint that gets filed, you have to respond to it. And typically if you're hiring an attorney to do that, you're spending several thousands of dollars in dealing with a response to that. And then you're also dealing with, okay, do they find that there's probable cause that there was a violation? And then you go through and, can you reach a settlement? If they find that there's probable cause, you don't reach a settlement, things can escalate from there. So, and Damien, you know how much it costs to file a complaint with the CCRD?
Oh, it's expensive. It's like, I don't know. It's so unbelievable.
It is. It's yeah. So I see we've got a new panelist here.
Yeah, Brady is weighing in on what he thinks about this too. So
What do you think about all these law changes? Good or bad? Good. Okay.
Oh, I see.
Not my son. Not my son. Okay, not my son. Okay. Here's another one real quick, Pete. On an application, if a tenant's bank statement does not identify where the money is coming from, can you say this is not verifiable income?
To me, that sounds problematic. I think you'd probably need to get some more facts on that, but I don't think it's that simple. I think the source of income is quite broad. A lot of things can, hey, I get gifts from a trust, or I get money from a trust, or I get money from a friend. I mean, there's a lot of different ways that somebody could say they have some income. So it really does create a limitation on your ability to screen somebody based on income, right? I mean, I think that's where a lot of these questions are getting to, and I think it's tougher now with some of these changes as far as eviction records are sealed, your limitations on what you can look at for background checks, how long you can go back on background checks, looking at your limitations on source of income. It is just it's tougher to be a landlord. But I think the thing is that what that does is it also embraces the opportunity there for those who are doing third-party fee management to say, hey, look, this stuff's tough. Let me handle it. I'm going to, take this on. And it really can be a benefit to thrive in that environment.
Here's another, in your professional opinion, you're not going to want to answer this, but I'm going to ask it anyways. In your professional opinion, with the hot market to sell, with the change in rent laws, is it better to just sell the rental or to stay a landlord in the landlord lane? And I guess the question probably relates to how difficult it's getting, landlords, it's getting tougher and tougher to keep up with the rules and the laws and everything else. And what are you seeing as far as what landlords are doing?
So what I am seeing is I'm seeing people that have been in the industry for a while, people that manage properties professionally, they're selling their properties in Colorado. They're saying, look,
that's what I'm seeing too.
Yeah, they're saying, we're out. We're saying goodbye. I don't think there's any shortage of landlords in Colorado. I think there's other people that are saying, hey, look, I will take this on. I'm going to take on this challenge. And that's fine that there's a balance, but I think there's definitely a shift, and it's pushing people out. I think you've had a run up in prices too, and when they're weighing, hey, I've got some equity here that I'm sitting on, or I've got some of the challenges that come with property management here that are going to only become more complex moving forward. I think they're making the choice to cash out. Yeah,
and I'm seeing is it's the small landlords that are making that choice. I mean, the big corporate landlords obviously are going to keep running their business and doing their things. And you've got a lot of these big corporations that are now getting into single family residential too. But it seems to be more the small mom and pop, I'll call them, outfits that are deciding to take their money and either take it somewhere else or just take it out of it.
I think there's definitely a lot of that, and I have seen it from brokers that have, you know, more than a few properties on their own. They know the industry well, and they're opting to say, we're gonna step out this time. You know, I mean, I think that it's an individual decision for, you know, what's your tolerance on risk, and, you know, where do you want to put that money? You know, or you're like, hey, I'm all in on crypto. Well, good for you, right? It's your money and it's your choice, but it is a little bit of a disturbing trend to see, you know, the mom and pops just say, look, I'm gonna step away from this. But again, I think there's that opportunity for the professional property manager to step in and say, hey, look, you know what, continue to do this. I can help. I go to classes to get trained on this stuff. I am familiar with this industry and I'm up to speed with these things, and here's the value that I can add. So I think because of those additional challenges, it does create that additional selling point for professional property management.
Yeah, they become much more important in this environment than they might have
Absolutely.
been in other
Yeah.
environments. I got a couple more on source of income. So if you have screening criteria of income must be 2 times monthly rent, and the income plus Section 8 voucher, they don't reach that threshold, is that okay?
I think you've got to be careful when you're talking about that sort of a screening situation to look at what is their portion and plus in the voucher, right? Because the voucher is not something that they can go out and it's not fungible, right? You can't go out and say, well, you know, I'm going to go get some groceries with my Section 8 voucher. You can only use that for housing. So I think you really have to change that, how you frame that, and look at what's the tenant portion and how does that compare to what your income needs are? Because chances are they're going to qualify based on that portion. So you don't want to be in a situation where you're denying somebody, saying, hey, look, you don't make enough, but you're looking at that voucher as part of what they're making.
Yeah, agreed. What about here on an application? Can you consider one type of income better when looking at 2 applications? Like one is making $5,000 a month self-employed, and the other is making $5,000 per month W-2. All sorts of fun ones, Pete.
Yeah. Did you catch the eyebrow raise? I was trying to get that over glasses. I'm not sure if I think that gets problematic, right? Because you know, when you're talking about discrimination is basically treating 2 people that are similarly situated differently. And so that question kind of goes right to that issue of, hey, that could be that could be a problem as far as weighing one better than the other.
This one is changing over to the Denver. You know, Denver's got that license requirement. And the question is, don't all landlords have to register with the city this year? And obviously this is in Denver. Does Boulder have something? Pete, you know better than me of the municipalities that may or may not have this.
Yeah. So Boulder does have a licensing requirement. So if you're going to rent a property in Boulder, that has to be licensed. Denver does have a licensing that they're rolling out. And so they are, and I just see somebody, I think Tanya said something about Fort Collins. But Denver's, there's still a little bit of time to register for Denver. So it's kind of the early stages of that registration to get in. I think there's some discount as far as the fee that is available. But yeah, that's, you know, if you're an owner in Denver, you're going to have to register that property, and it's a very good chance you're going to have an inspection done as well. And when you have an inspection, you know, there's only so many people. In fact, very few people right now that are listed as the list of inspectors that are approved to do the inspection. So you have to have, you know, a high level of certification to qualify as the inspection. So it's definitely something to pay attention to if you have rentals in Denver. Don't procrastinate on that.
And then along those lines, somebody else asked, if you are renting out a room In other words, you're the owner occupant of the property, but you're renting out a room. Are they still constrained by the same licensing and inspection requirements?
I think there might be some short-term rental issues because there's a separate short-term rental requirements that have been in place for a while now. So I think there's probably an exception, and I think it's based on a long-term rental, but I'm just going off the top of my head here. So don't quote me on that.
Okay. Sorry, I'm trying to.
No, you're good. Thanks for
my wife is busy with a kid, so I'm trying to help her.
Believe me, I think she's got her hands full more than you do.
She does. I have somebody that's asking questions about how far away from California type laws, making it very difficult. I mean, I don't think we're quite to the same point that like regulation that California has, but it's getting closer.
It's getting there. I mean, it's I've talked to clients that live in California, have properties out here, and they've got some special horror stories. So if you think it's rough here, talk to somebody in California or talk to somebody that's got properties in the Pacific Northwest too. They've got some very challenges for landlords. So
okay. Let's see. Can you put on an application, you will not review them until you have 3 applications submitted and will take the best application?
I think that could create some problems for you because basically you're putting their application status based on what somebody else is going to do. I think it's probably better to deal with that in the order that they come in.
Okay, the last one I'm going to ask you, and then we'll let you go is, and I'm curious what your opinion is on this because I have a feeling you and I might have different opinions, but we are first-time landlords renting out our old home. What would you recommend for business structure for the rental property, given it has a mortgage left on it and we can't transfer it into our LLC?
So you can't transfer it into your LLC. So I'm guessing you've already indicated that we'll assume for this situation that the bank has said, look, you can't put it into an LLC. And so that's not a possibility for you. The tough part with that type of situation is what's your risk going to be? And, putting property into an LLC is one way of trying to manage risk and trying to create sort of a separate target of if there's something that happens at the property, you're dealing with the LLC and not the individual. But there's other ways to deal with that managing risk too. So you could deal with that potentially by having very good insurance to help deal with any claims that might pop up. And then you also might have a situation where how you're managing the property. So again, I think if you're self-managing the property and you're not a professional property manager, I think that's an issue. Having a professional property manager help you with managing the property, I think could be very beneficial. So I know that's a little bit of a dodge as far as dealing with the structure, but I think it's kind of dealing with the risk because I think that's what people are really asking when they're talking about, hey, I've got this rental property, what do I want to do? And that's that consideration of, if you can't transfer it to an LLC, you're probably going to have the same issue if you're going to transfer it to any other type of entity, right? So look at managing that risk somewhere else.
I actually don't think transferring to the LLC does much for you, in my personal opinion. I always tell people over-insure. Umbrella policies are a great thing. Over-insure the property, and then a property manager is even better because then you're not responsible for your own torts if something happens. But what people tend to forget, if your house is determined, if somebody falls in an open mine shaft that you left open and you're negligent, you're going to be responsible for your own negligence. And number two, they're going to sue for all the equity in the house anyways, because that's your LLC or whatever it is going to have that equity. So they're going to get that no matter what. So what are you really protecting? You're better off over insuring to be sure. I mean, that's my answer typically.
Yeah.
I did have,
we're not that far off.
See, we're not that far off. I just don't like the LLCs as much as everybody else does. But I did have one more question, then we'll call it a day. Somebody was want to go back to the late fees. And they were asking, so the $50, the minimum, that's not per day, that is per month.
That's
correct?
per month. Yeah.
Yeah.
So that's the, $50
Or 5%, whichever is greater per
Right.
month, period. And that
That's
is it. So, okay, honey, you got anything else? Brady, you got anything?
You need anything to add, buddy?
Yes, Dad.
Hi, monkey.
I think that's it.
All right.
Yeah, thank you so much, everybody, for joining. Pete, thank you so much again, as always, for all your time and just sharing with us these wonderful updates.
Thanks. Appreciate the opportunity to be here. Always great to see you guys, and good to chat with your the attendees. So good to see everyone.
Thanks, Pete. We'll see you
Thanks
later.
so much, everybody. We really appreciate you. Yep, we'll see you next month with Marcia Waters, and reach out anytime if we can help you. So thanks so much. Have a good week.
One, two.